Hello, welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking with Bruce Robinson of Robinson, Kennon Kendron in Lake City, Florida. Bruce is a board-certified civil trial lawyer and has been since 1983.
1983.
Very impressive. Bruce, welcome. Thank you for joining us here today.
Well, thank you. It's a pleasure to be here.
Today we're going to be discussing depositions. The taking, the use, the ins and outs. Bruce has some very good details for us. So Bruce, let's just dive right in there.
Well, I brought a little cheat sheet with me because I can't remember everything, but it's important to really know what the rules that affect you are. And remember that Rule 1.280 is the rule that defines really the scope of discovery under our rules of civil procedure. And the rules that follow through Rule 1380 are the rules that govern our discovery practices. But I'm going to talk about primarily Rules 1.300 and 1.310. It's important to understand, too, that what's the scope that I set forth in 1.280 is anything that relates to any claim or any defense, and it doesn't have to be admissible per se, but just reasonably calculated to lead to admissible evidence. May not ultimately end there, but the courts in Florida have given very broad latitude there. I think it's important to understand certain things too, though, and that actually a deposition can be taken before a court reporter or notary public, any officer authorized to take acknowledgments, or anyone appointed by the court, though as a practical rule, we virtually always see court reporters do it. I think that we are going to see that change some in the coming years because the cost of litigation in my shortly 43 years of practice has risen exponentially. Now, you will from time to time have to take a deposition in another state. Please be aware that Florida is a signatory to the Uniform Foreign Depositions Act, as are most states. An even lesser known fact is that the United States is a signatory to an international treaty on discovery in commercial and civil litigation. Not all countries are, of course. The less sophisticated they are, the less likely they are to participate. But there is an international convention on that, just like there is on airplane flight, like the Warsaw Convention. So it's important to know that you can take depositions in other states as long as you comply with the Uniform Foreign Depositions Act. I won't try to go into that because that's a little more of a technical area as well. And I won't bother to go into the international taking of depositions because unless you do a lot of international practice, you won't run into that too often. However, if you have a lengthy litigation career, sooner or later you will. So if you want to take a deposition in a foreign country, you can do it a number of ways. You can take it in a foreign country, and you can take it according to the law there, your state, or the United States government, so long as they will apply it the place you're located. Typically, you will get someone commissioned by the courts here to do it, or you can do it by letter rogatory. I've never seen that happen. That's a letter written from a court in one country to a court in another country asking for comity. Sounds great, but I've yet to see it occur. I mean, I'm sure others have, but I have not. Now, the parties, if they agree, can always stipulate to some other process. Now, when can you take a deposition? You can take it, if you're the plaintiff, only after 30 days after service. If you're the defendant, you can notice it sooner, but when you do, then the plaintiff is no longer bound by the 30 days either. So, let me go over a few other things that I think are important to know. Now, how do you get someone that's a non-party to come to a deposition? Well, you have to subpoena them. and it can be a subpoena to appear or a subpoena ducis tecum. If it is a subpoena ducis tecum, though, you must identify in the subpoena the items for them to bring or attach that subpoena to the notice of taking deposition that you send to your opposing party, because your opposing party has a right to know what documents you're expecting to show up at the deposition. Now, if you want to depose someone in jail, which happens more often than we'd like to admit because we seem to have incarcerated one of the highest percentages of our population of any nation, or at least of the more developed nations. But if you want to depose someone that is incarcerated, it requires an order of the court to do so. And I find that lawyers frequently don't realize that. So it's just a point to be aware of, and that's what we're trying to cover. Now, how much time do you have to give someone about a deposition? Well, the rules talks about reasonable notice. Well, what's reasonable may vary under the circumstances. There's no hard rule on what's reasonable. It can vary a great deal. Now, you can take a deposition if you are the plaintiff and you have reason to believe the person you need to depose inside the 30 days. If you believe the person is about to go out of state, is gravely ill, on his deathbed or something of that nature. Matter of fact, you can even take a deposition before you file the case. If you have fear of a person dying or about to leave the state or the nation, there are provisions for doing that. But when you do that, you must immediately notify the expected parties that you are going to do so, and if they can't obtain counsel, then you may not be able to use it against them. Another thing that you have to watch for is if you take this deposition inside 30 days after filing, and the other party can convince the court that he was unable to obtain counsel to protect his interest there, you may not be able to use it against him either. So there are a lot of little things here that you need to be aware of because depositions are among our most common tools. Now, if you want to take a videotape deposition, and we see more and more of those, you need to know certain things about them. You don't have to have leave of court, but you must put in the notice that it will be a videotape deposition. And when you take a videotape deposition, you need to understand that as the taking party, you are responsible for maintaining and safeguarding the original videotape. Now, once you do that, if someone asks for a copy of the videotape, you must provide it to them, but at their expense. However, the actual initial cost of taking the video deposition is borne by the party who wishes to do so.
As a practice tip, Bruce, as the practitioner, how do you choose whether or not you want to do it as a video deposition versus just on paper?
If I think that I'm going to take a party, for example, who is, let me put it this way, a very unlikable character who is prone to poor behavior, poor mannerisms, then I will frequently videotape that person.
All right, well, that's certainly a good practice tip. We're coming up on time for this video, but we can certainly film more videos on a series with depositions. So I do encourage you to check back with us on the Mentoring with the Masters website. Thank you for joining us, Bruce.
Well, I enjoyed being here. Thank you.
Thank you.